Go.
Hi, my name is Linda Mendoza. I'm one of the co-chairs for the Valley Mountain Regional Center Legislative Committee. And this morning, we're going to be presenting a presentation on the new laws that have been impacting our committee. The first slide you read here is the 2021 new laws impacting the intellectual and developmental disabilities IDD community, VMRC Board Public Policy Committee. Next, we're going to have Tony speak a little bit about his part.
Thank you very much, Chairwoman Mendoza. So what we do as a committee is we track the bills that are impacting our community. Sometimes they're very clearly impacting people with developmental disabilities because they say that. And other times, people with disabilities or seniors, people with mental health disabilities, or a variety of other areas that might impact our community as well. And so we'll look at them. And then we also look at the budget a little bit, because the budget is, it's a piece of legislation, and we want to see how that changes law as well. So this, what we have for you, this slide right here, is the process that we go through and follow as a committee. So it's what happens in the legislature, and we won't go into great detail on here. This is actually the simplified version of I'm Just a Bill in California, and it's sort of the path that they take. You'll see that there's a on the left side, there's the bar, and this is how it should go. There are probably as many different graphs of how it actually goes for any given bills, but this is how it's designed to work. And so what you have is the beginning process. When you have a bill on the top is the process that the Senate goes through. California has a bicameral system, just means two houses, a Senate and an Assembly, and the Assembly is known as the People's House. It's known as that by the Assembly. And so that's where the two processes go, and they're pretty similar processes. And as you can see on the top, you just see that you've got a Senate bill, and then there's a reading of the bill, so everybody kind of understands that this bill is out there. And then you get that bill assigned to a committee, and then the committee starts their work. And then sometimes this rules committee decides that it goes to more than one committee. So they might have different committees that it goes to, and it has a process there. And if it's going to cost money, there's another committee called the Appropriations Committee. And so there's a variety of different places that could go, but once it makes it through their own house, then it goes over to the other side, and that bill then has to be approved on the other house. So in California, we'll run a bill through the Senate side, and then we'll run a bill through the Assembly side. They'll finish their called House of Origin vote, and if it passes, then it gets to go to the other house, and then they do similar things with that bill, and it eventually makes its way through and makes modifications often, and then in the very end, they pass both houses, and they come through and they make it to the governor's desk, and then the governor, he or she, will have their process, and in the very end, the bill gets chaptered. And you'll see in some of these bills, we call it chaptered. We'll note that the bill has been chaptered, and most of them will become law in January of that next year. So that's how that process goes. But sometimes they become law at a different date, and they're specified in the bill, but they have to be urgent. So anyway, that's what we do as a committee. We watch it as it moves through the Senate side, and we watch other ones through the Assembly side, and then we pay more attention at the very end when the governor is signing these bills from September through October. So then we get some time to analyze them, put them together. We cover them as a committee, and then we put together a little presentation of the ones we watched that made it through, and that's where we are today. So now I'll move on to the first set of bills, and that goes to Karen.
Karen, you're on mute.
Thank you. Thank you, Tony. I'll get us kicked off by a bill that impacts children. SB 354. It was introduced by Senator Nancy Skinner. It's in the arena of public social services. This bill was approved by the governor and chaptered by the Secretary of State. And it's in regard to a child who has been removed from their parent or guardian. And this bill would authorize the court to order placement with a relative, regardless of the status of any criminal exemptions or resource family approval, if the court finds that the placement does not pose a risk to the health and safety of the child. So this bill would require the county welfare department to use reasonable efforts to assist the relative or non-relative extended family member in obtaining the necessary items. This bill would impose a state mandated local program. Next slide, please. All right, also a bill impacting children. This is an assembly bill, AB 1363. It was introduced by Assembly Member Luz Rivas, and it impacts dual language learners in preschool. Currently, the Early Education Act has one of its purposes to offer an inclusive and cost-effective preschool program that provides high-quality learning experiences and coordinated services and referrals for families to access health and social emotional support services through full and part-time programs. This bill would include as a quality indicator program activities and services that meet the needs of dual language learners for support in the development of their home language and English. The bill would also require the superintendent to develop procedures for state preschool contractors to identify and report data on dual language learners enrolled in a preschool program, and would require the reported data to include, among other things, a child's home language and the language composition of the program. And that's all I have. Next, we're going to civil rights and recognitions.
Thank you, Karen. If you see the civil rights and recognitions, there's a couple chaptered bills here on the first slide, ACR 28, ACR 39, ACR 45, ACR 73, SB 317, and SR 14. Tony, I'm going to ask if you can talk to us a little bit about that.
Okay. What we have two different sections here. First of all, the recognitions, and there are a series of bills in here that are the legislator puts forward, and they call them Assembly concurrent resolutions or Senate resolutions. And the reason for them is that the legislators want to bring attention to a particular issue that's important to the state, and these are the recognitions. On the next slide will be the civil rights piece, and so Robert will cover those. But the recognitions that they put forward this year is that we were watching was the National Caregivers Day. So Assemblymember Calderon put that forward, and it was a recognition of all caregivers who are caring for seniors or people with disabilities at home. And so this is a moment to recognize the importance of caregivers. And then the Assembly Concurrent Resolution 39, what Holden was called Roxy's Wish. And what they did is they spent some time on the floor discussing the importance of drowning prevention, the issue and the impact that drowning and near drowning has on our community. And so they discussed that on the floor of the Assembly, and then they recognized this week that they had listed as the week to sort of honor and pay more attention to drowning prevention. They had the ACR 73 by Fraser, and that was the Autism Awareness Month. And that one was when the time of the year that the legislature chose to recognize autism awareness, and it's a national awareness month, but also the state wanted to put forward their own special recognitions as well. And then the last was the social work month, so it's another awareness month. So SR 14 by Eggman, who is actually a former social worker, and she put forth this the Senate Resolution 14, and in Senate Resolution 14, the Senate recognized social workers and the impact that they have on community. So those were the few bills that come up, and they don't go to the governor. They go and they're completed on their own in their own house and recognized on their own floor as something of importance that the legislature is recognizing for the state. Next slide. There you go. Now we go to Robert.
Thank you. Existing law requires county elections officials to mail a ballot to every registered voter for all elections proclaimed or conducted prior to January 1st, 2022. Existing law requires county elections officials to use specified Secretary of State, Secretary of State, where is it?
Secretary of State vote by mail.
Oh, Secretary of State vote by mail tracking system, or a system that meets the same specifications. This bill would extend the requirements to mail a ballot to every registered voter to all elections and apply them to all local elections officials. This bill would require a vote by mail tracking system to be accessible to voters with disabilities. This bill would also make various confirming and technical changes. This bill contains other related provisions and other existing laws.
Do you want to talk a little bit about that? How you feel about that?
I think it's important to do that, to assist the voter, in essence, protecting his rights. So I think it's very important that we deal with this. And I appreciate your time. I've got another, okay. Existing law prohibits a person from being tried or adjudicated to punishment while that person is mentally incompetent. Existing law prohibits a process by which a defendant's mental capacity is evaluated and by which the defendants receive treatment, including if applicable, I'm sorry, antipsychotic antipsychotic medication with a goal of returning the defendant to a competency, excuse me. Existing law suspends a criminal action pending restoration to competency. This bill would repeal previous. This bill would repeal previous regarding the restoration of competency for a person charged with a misdemeanor or a violation of violation of probation for a for a misdemeanor, including provisions regarding administration or antipsychotic medication. The bill would instead authorize the court to conduct an inquiry. Inquiry into the defendant's capacity as specified. The bill would authorize a court, upon finding the defendant incompetent, to stand trial, to suspend the proceedings and take certain actions, including granting division not to exceed 1 year or dismiss the charges as specified. This bill contains other related provisions and other existing laws.
So when Robert and I were reading this, we had a question. We said, what does granting diversions mean? And so we reached out to a local attorney, retired, and asked for clarification on what that means. And what we were told was this basically gives a judge more discretion for misdemeanor cases, to either dismiss the case or ask the person to maybe complete a program. And when that program's completed, a misdemeanor could be dismissed by a judge. It's becoming more popular recently from what we hear. An example would be like a drug charge or a drunk driving charge. And instead of, if the person's found incompetent, instead of going through the court process, they could go to a diversion program. So a drug program or a drunk driving program, and for up to a year. And as soon as that program's completed, a charge would be dismissed instead of going through the legal system. So that's our understanding of this one, right, Robert?
Yes.
And that's all we had. Next up, we have Katrina in community access.
Okay. Well, internal care and services, executing law, the Nursing Practice Act, established the Board of Registered Nurse within the Department of Consumer Affairs for the legislature and regulation of the practice nursing, and requires the board to issue a certificate to practice nurse midwife to a person who, amongst other qualifications, meet educational standards established by the board or the requirement of those educational standards, executing law, the Licensed Midwife Practice Act of 1993 provides for the licensure of midwives by the Medical Board of California. This bill would enact the Midwife Workforce Training Act, under which the Office of Statewide Health Planning and Development would, upon application, approximation by the legislature, contact with programs that train certified nurse midwives and programs that train licensed midwives to increase the numbers of students serving quality education and training as certified nurse midwife or a licensed midwife as specified. The bill will require the office to contact only with programs that include or tended to include a component of training designed for medically underserviced multiplicational communities, lower social neighbors, or regional communities, and that are organized to prepare a program, graduates for service in those neighborhoods and communities. This bill contains other related provision or other executing laws. Position and watch. Next slide, please.
Oh, and that looks like that's me, Miss Katrina. Thank you
Yes.
so much.
You're
So,
welcome, Dina.
hello, everyone. I'm Dina Hernandez with the State Council on Developmental Disabilities North Valley Hills office, and I am a proud member of this legislative committee that is dedicated to sharing information with all of you that may be helpful. So on my slide, I'm going to be covering community safety. So there's a few chaptered bills here. I'm going to just go through them one at a time. So our first one, which is AB 57 by Gabriel, which is law enforcement hate crimes. So there's a current law that any law enforcement agency that adopts or updates a hate crime policy to include specific information, that the policy, including information on bias motivation. This bill would include a statement of legislative findings and declarations and require a basic course of curriculum for the hate crimes. There's a group called the Peace Officer Standards Training, or POST, P-O-S-T, that provides training to law enforcement and first responders. Folks from the State Council, our office, are POST certified trainers. For this particular bill, it will mean that there will be a special segment dedicated to hate crime so that law enforcement is aware of what is going on. This would also require POST, the P-O-S-T, to make a video available via online the learning portal, and would require all peace officers to complete a specified training no later than 1 year after the commission gets the updated course materials available. The bill would require POST to develop and periodically update an interactive course on hate crimes for in-service peace officers, and requires officers to take the course every 6 years. So currently, POST has a website that law enforcement can go to and access certain courses that they must take in order to maintain their employment. And so this will be an added feature to that portal. Next one is AB 118 by Cam Lager, Department of Social Services Crisis Grant, CRISES Grant Pilot Program. So what this means is it would enact the Community Response Initiative to Strengthen Emergency Systems Act. That's what CRISES stands for purposes of creating, implementing, and evaluating the Crisis Grant Pilot Program, which this act would establish. The bill would require the department to administer the program if appropriate funding is made available to the department. The bill would require the department to grant grants to, oops, I'm sorry, I flipped the wrong way, to qualified grantees, which would include city, county, and tribal departments of social services, disability services, health services, public health, or behavioral health based on grant eligibility criteria developed in partnership with stakeholder work groups. Our next one is AB 580 by Rodriguez, Emergency Services for Vulnerable Populations. What the current law says is there is an Office of Emergency Services, or OES. And so the law requires OES to establish a standardized emergency management system for use by all emergency response agencies. So this is a way to keep us safe in all the growing emergencies that have occurred, particularly in California, on a response system that would be open to folks with disabilities and their needs. So the current law requires the director to appoint representatives of the disabled community to serve on pertinent committees related to the system and to ensure that the needs of the disabled community are met within that system by ensuring certain community recommendations. This bill would instead require the director to appoint representatives of the access and functional needs population, which is not just folks with disabilities, but opens it up to a wider group of minority groups that need to be included in this, and provide appointees to the specified group. We do have a self-advocate from our region who has been appointed to the access and functional needs under the Office of Emergency Services. So we'll look to her to learn more as this progresses. So that was AB 580. And my last one on community safety is AB 749, Skilled Nursing Facilities Medical Direction Certification. So this would prohibit a skilled nursing facility from contracting with a person as a medical director if the person is not a medical director or will not be one within 5 years of the date that they were hired. Apparently there's been some concerns and issues regarding this. So this law would make it mandatory that an actual certified medical director is employed at a skilled nursing facility. If there currently is a medical director at a nursing facility, January 1st, 2022, they would have until January 1st, 2027 to become certified medical director under the rules of this bill. And that is the end of community safety. And I believe I have the next slide also, which is employment. And the two bills I'm going to briefly talk about is the first one is AB 313 by Christina Garcia. It's a civil service limited examination and appointment program. We call it LEAP, L-E-A-P. And so what it says is the current law policies this state with regard of hiring individuals with disabilities and prescribes responsibilities of the Department of Human Resources that relate to the representation of individuals with disabilities in the state workforce, meaning state agencies need to be hiring folks with disabilities to be part of the state workforce. It's a very difficult process to get into state service, and this LEAP program is designed to help folks to be able to get through that with a little bit less barriers. This bill would require that each state agency develop its own reasonable accommodation policy for individuals with disabilities, consistent with state and federal law to address requests for reasonable accommodations. The bill would require the Department of Human Services by December 31st of each year to review affirmative action employment plans submitted by the state and to approve the plans or to require appropriate modifications as specified. The bill would require each state agency's equal opportunity program to include a reasonable accommodation with the goal, of course, of employing more folks with disabilities who are interested in civil service. Our office can also help folks with the LEAP program, so we are a resource to all of you. My last one is Senate Bill 639, which the State Council, along with other state agencies or Disability Rights California, worked on, which is Senate Bill 639, minimum wage for persons with disabilities. So the current law establishes a minimum wage for all industries and makes it a crime to pay an employee less than minimum wage fixed by the Industrial Welfare Commission. So the current law, however, permits the commission to issue an employee who is mentally or physically disabled or both a special licensing authorizing the employment of the licensee for a period not to exceed 1 year from the date of issue at a wage that is less than minimum wage. That's called a 14C, a waiver. Current law requires the commission to fix a special minimum wage for the licensee, which may be renewed on an annual basis. This bill would prohibit those new special licenses from being issued after January 1st, 2022. The bill would permit authorizing a lesser than minimum wage for an employee who is mentally or physically disabled. It would be inoperable, meaning they cannot do it on January 1st, 2025, or when the multi-year phase out of this plan as specified is released, whichever is later. So the State Council and Disability Rights California and many other stakeholders are working within California, which California was the 13th state in the nation to pass this law of getting rid of sub-minimum wage. So there will be a lot of work in this area in our region moving forward. And that is all I have. I believe I go to Doug.
Yes, thank you, Dina. I will be covering a couple of bills that are related to health, and in particular healthcare. So the first one that you see up there is Assembly Bill 457. It's the Protection of Patient Choice in Telehealth Provider Act. So right now, current law basically says if you're in the healing arts profession, that you're licensed and regulated by the Department of Consumer Affairs, and it's not lawful. So it's against the law for licensees like this, except as specified, to either offer, deliver, receive, or accept any rebate, refund, commission, preference, patronage, dividend, discount, or other consideration in the form of money or otherwise as compensation or inducement for referring patients, clients, and customers to any one person. And so what this bill would do was it would provide that the payment or the receipt of consideration for internet-based advertising, appointment booking, or any service that provides information and resources to prospective patients or licensees, it does not constitute a referral of a patient if the service provider doesn't recommend or endorse a specific licensee to a prospective patient. So very, very important stuff there in terms of protecting patients' choice, being able to choose their providers. And then the next one is Senate Bill 221. And this is in regards to timely access to care. So current law basically says that all managed healthcare providers and health insurers are regulated by the Department of Managed Healthcare or the Department of Insurance. And they, each department has to develop and adopt regulations to ensure that their clients, their enrollees, their insureds have access to healthcare needs in a timely manner. And what this bill does is it expands on the timely access to healthcare and ensures that people who have non-physician appointments, so you have an appointment with somebody that's not a doctor, say mental health or substance abuse disorder treatment, that they have to follow the timely access requirements too, so the patient is able to receive care in a timely manner. If there's a follow-up appointment, this bill requires that the follow-up appointment be provided within 10 business days, so a more timely manner. If a referral is made to another specialist, the timely access manner requirements are still in place. And if there is not a provider in the network and they have to go to a different geographic region, that is still required to be done in a timely access manner law. So that's basically making sure that patients get their care in timely access. And that's my health section. And I believe Candace will cover housing next.
Yes, good morning. My name is Candace Bright. I am the co-chair and really enjoy being on this committee. So thank you for having me. So the first chapter bill is AB 571. by Chad Mays. So basically, this has to do with the density bonus law, which requires the city or county to provide a developer that proposes a housing development in a city or county with a density bonus and other incentives as it relates to the number of low income, lower income, and moderate income households. So the existing law requires that the amount of the density bonus and the number of incentives or concessions be pursuant to a certain formula. So what this bill is has changed is that they would prohibit affordable housing impact fees, including inclusionary zoning fees and in lieu fees from being imposed on housing development's affordable units. So basically, how I understand it is California is trying to increase the amount of lowest, lower, and moderate income housing units, and incentivizing developers by getting rid of fees. So I think that'll be great for us with our housing crisis. The second bill is SB 8 by Nancy Skinner. And so this law, the Housing Crisis Act of 2019, the act defines the housing development project to mean a use of consisting of residential units only, and mixed use developments consisting of residential and non-residential uses use at least 2/3 of the square footage for residential use, and transitional or supportive housing. So this bill was meant to clarify the various purposes of the act, and to involve no discretionary approvals, and that it would specify let's see. It would just make it so the act is more able to be easier to understand. So everything that was submitted before January 1st of 2020 would not be affected, but all of the projects that were submitted after January 1st would be, there would be less, I don't know, this is very difficult to understand. So it could also include single units. So instead of being related to mixed use developments, you can also use it for single unit. So that's my understanding. Correct me if I'm wrong, but housing is not the easiest thing to understand, especially in California. So the next section I had was mental health. The first bill is SB 14 by Anthony Portantino. This bill is actually very interesting. So as it relates to children between the ages of 6 and 18, that they're allowed to use mental health as a reason for not being at school. Absence related to illness could be related to mental or behavioral health. So it would require the State Board of Education to update its illness verification regulations to account for including a pupil's absence for the benefit of the pupil's mental and behavioral health within the scope of its provision. And it would also impose additional duties on local education entities and a state mandated local program. And so with SB 224, this bill would require that each school district, county office of education, state special school, and charter school offer one or more courses in health education to pupils in middle school or high school, to include courses in mental health. And the bill would also require that there be reasonable designed instruction on the overarching themes and core principles of mental health. and that there would be instruction and related materials, among other things, to be appropriate for the use of pupils of all races, genders, sexual orientation, and ethnic and cultural backgrounds, pupils with disabilities, and English learners. The bill requires the State Department of Education to develop a plan to expand mental health instruction in California public schools on or before January 1st, 2024. So it appears that the education system will start hopefully normalizing mental health and educating our children on it, and hopefully making it not so stigmatizing. So I look forward to seeing how California is able to implement this. Next, we had originally Margaret Hines, the president of the board, but she doesn't appear to be on here. So Doug, is that you?
Yes,
Okay.
yes, I will be covering for our fearless president, who is an education professional. And so we have a few bills to go over. The first one is Assembly Bill 10, and it's regarding in-person instruction and then distance learning. So I'm going to read this as read, and then I'll give you my interpretation. I believe it's kind of COVID related. So it says existing law establishes a system of public elementary and secondary education in this state and authorizes local education agencies throughout the state to provide instruction to pupils in kindergarten and grades 1 to 12 inclusive. It also establishes procedures for the apportionment of state funds to the local education agencies. For purposes of calculating apportionments for the fiscal year, it requires an education agency to offer in-person instruction, but it also authorizes these agencies to offer distance learning as specified. So this bill would specify that the requirement to provide in-person instruction applies when that instruction is allowed under state and local public health orders. So I'm guessing that it's covering the fact that sometimes in the past couple of years, state and local public health orders were not allowing for students to attend in-person instruction. So they're just clarifying that this bill only applies when in-person instruction is allowed by state and local health agencies, is my interpretation of it. The next one is Senate Bill 237, and this is regarding dyslexia screening. So currently there's programs in place to assist regular education teachers, special education teachers to assess for dyslexia and to see if they're eligible for special education for services if they are assessed and found to be diagnosed with dyslexia. What this bill does is the State Board of Education will have to approve a list of evidence-based and culturally, linguistically, and developmentally appropriate screening instruments to be used by local education agencies for dyslexia screening. It would require, beginning 2022 and annually, that the local education agencies screen for dyslexia in grades kindergarten through 2, using those approved screening instruments. And then also eventually it will extend to grade 3 for dyslexia screening. And then it also requires the results of the screening to be made available to the children's parents no more than 45 days from the actual screening. It also would make children who are identified to be as at risk for having dyslexia to be provided more appropriate intervention and instruction and monitoring when they're identified to be at risk of having dyslexia. So that's Senate Bill 237. And then the last one I have is Senate Bill 291. And this one is regarding advisory commissions on special education. and establishing a pupil advisory council. So right now, there is an advisory commission statewide on special education, and there's 17 members. And what they do is they study, provide assistance and advice to the State Board of Education, the superintendent of instruction, the legislature, and the governor on anything coming up new regarding research, program development, evaluation to be used within special education. But what this bill would do is establish an advisory council that would also include 10 individuals with exceptional needs, age 16 to 24. So it's including professionals, but also people who have a special need or an exceptional need. A bill would also require the state to nominate a pool of qualified candidates for appointment to the council, and would require the superintendent to appoint the members of the council from that pool of candidates. Let's see, it would require the council to hold meetings that are open to the public and to conduct the meetings virtually, except when it's necessary to conduct a meeting in person. And it would increase the number of members on the commission to 18. And that's my education section. And I believe we're gonna go kick it over to Tony and Candace for the next section.
Yes, thank you. So just a reminder too, on the education bills, we thought we'd bring them forward so that the audience could see a couple of the bills that are still out there. They're still sort of, they still could happen, but they did not pass. Most of these other bills are passed, and this one, we listed them as not chaptered, meaning that they haven't passed, so there's no chapter for it in law. So, but just as a reminder to the audience on those, on education, we thought they were interesting. In this section here, Candace and I are going to cover a few bills here. Now, I'm going to do the one that ARCA was the sponsor for, and that's AB 445 from Assembly Member Calderon. And in this one, 445, the current law was saying that the department who contracts with the regional centers requires the regional centers in their contracts to get certain information, and some of that information includes the individual social security number. That's the social security number of the parents of the consumer, and the regional centers were asked to collect that for each new case. And what we find, especially regarding out-of-home placement, anyway, what we find is that that can be a barrier to moving forward in providing services and supports for some people. And so what we've asked is that not be, that requirement be removed. And so that's basically what this bill does. And it was passed and it was signed by the governor. So that should be very helpful for regional centers in supporting people where that was a barrier. So we'll move on to Candace then.
Yes, thank you for the reminder that I was doing this slide. So AB 232, no, 323, sorry, dyslexia there that Doug was talking about. So this is related to compliance and type A, AA violations. So all facilities are regulated. We have type A, type B, citations. So this one, this bill here helps clarify and expand or redefine a AA violation as a Class A violation that determines that there has been a substantial factor in the death of a resident of a long-term healthcare facility. It would increase the civil penalties for Class A, AA, or B violations by skilled nursing facilities or intermediate care facilities. And it actually deleted the reference to the term patient in long-term care facility regulations. The second bill, AB 749 was already discussed. It related to the medical director. So that was already addressed. SB 311, Compassionate Access to Medical Cannabis Act, or Ryan's Law. So here the bill would allow for specific types of healthcare facilities to allow a terminally ill patient's use of medical cannabis within the healthcare facility with certain restrictions. The bill would require a patient to provide the healthcare facility with a copy of their medical marijuana card or written documentation that the use of medical cannabis is required or is recommended by a physician. And it would require the healthcare facility to reasonably restrict the manner in which the patient stores and uses medical cannabis to ensure the safety of other patients, guests, employees in the healthcare facility. Compliance with and other state laws and safe operations of the healthcare facility. It would provide that compliance with the bill would not be a condition for obtaining, retaining, or renewing a license as a healthcare facility, which is great. And it would require that healthcare facilities permitting patients use of medical cannabis comply with other drug and medication requirements as specified, and would make those facilities subject to enforcement actions by the State Department of Public Health. The bill would authorize a healthcare facility to suspend compliance with these provisions if a regulatory agency, the United States Department of Justice, or federal centers for Medicaid and Medicare and Medicaid services takes specified actions, including initiating an enforcement action against a healthcare facility related to the facility's compliance with the state regulated medical marijuana program. So my understanding, and Tony, please correct me if I'm wrong, since marijuana is not federally legal, and because these facilities are funded with federal funds, that by having the state put this bill, it's hopefully going to protect the facility and the use of medical marijuana. However, if the federal government were to get involved, then the medical marijuana could no longer be used. Is that your understanding? That's mine, potentially.
I don't know.
So it's great. Hopefully this allows patients to get the medication that they need. Minimum wage for persons with disabilities. I believe Dina addressed this. So yay for that. And then the SB 650 for skilled nursing facilities. It requires that it has to do with ownership. So this bill with financial years ending in December 31st of 2023 would, except as specified, require an organization that operates, conducts, owns, manages, or maintains a skilled nursing facility or facilities to prepare and file with the office an annual consolidated financial report that includes data from all operating entities, license holders, and related parties in which the organization has ownership or control interest of 5% or more, that provides any service, facility, or supply to skilled nursing. The bill would require a duly authorized official of the organization to certify and report. The bill would require the office to develop policies and procedures to outline the format of information to be submitted, determine if the annual consolidation financial report is complete. So with what has happened before is that the percentage was much higher. So, lower. So my understanding was that people had their hands in a lot of different businesses and weren't reporting that. And whether the business got in trouble or was under investigation or something of that nature, it wasn't reported. So by changing the controlling interest, it allows the state to kind of keep an eye on some of these providers that have their hands in multiple businesses, to make sure that if there's a violation in one company, that the rest of the patrons who are receiving services are protected. So hopefully this continues to help support and protect the people, the vulnerable population that we serve.
All righty. Yeah, I'm up right now. Thanks, Candace. Right? Are you done? I'm sorry.
Yes, I am. Thanks, Doug.
Okay. So these are the next, real quick, these are things that weren't law, but they were changed in the regional center contract with DDS. That's correct, Tony?
Mhm.
Okay, so the first one is use of facilitators, and what a facilitator is, and we have a facilitator on today. Rochelle Munoz is acting in the role of a facilitator for Katrina today. So we have in the regional centers, boards are required to be made up of certain amount of people that receive services from the regional center. We call them consumers or individuals with developmental disabilities. Sometimes if the individual board member would like a facilitator to help them, get prepared for the meetings, get answer questions about content in the agenda or the reports and the things that they're going to be voting on. Some people don't want a facilitator and some do. Some say, yeah, I could use the help. So this just is requiring the regional centers to be required to have a facilitator present for these self-advocates that serve on your board in all types of meetings. So I believe there was some closed session meetings at some different locations where facilitators weren't allowed to be in the room with that individual board member. And this says, no, you got to let the facilitator be with the individual and the board member to make any decision. That's the requirement that we're putting in place. So open meetings, committee meetings, closed session meetings, the facilitators are allowed to be in those meetings because that individual board member has the right to the facilitator. And so that's that one. And then the next one is cultural competence. So in the contract with DDS, the regional centers have to provide training to their board members, and they have to provide an annual plan to DDS on the topics of training, who's going to be putting the training on, and the dates of the training and things like that. So and new to this year was a component of training that requires a curriculum of cultural competence. So each regional center will have to include a cultural competence type of training in their annual training to their boards. So we've done that here. We have it scheduled and we've submitted our plan, and we're excited to add that. We feel like it's a very important piece of training for our boards to have, and we want all of our boards and board members to be as culturally competent as can be. So that is my section here, and it looks like I'll kick it over to Tony for budget initiatives.
Great, thank you. So this presentation today, as we talked about, is new laws that impact our community. And oftentimes people don't realize that the budget, they think of the state budget as just a budget agreement, but it's actually a law as well. And so it's a big law that these days includes a lot of different policy changes. Many years ago, there were very few policy changes that were done in the budget because they were just done in all of these bills. So all these bills that we are explaining to you, that was the bulk of how you made policy changes in all these different areas. So this particular year is probably one of the most policy changes I think I've ever seen done in the budget. So what we've got here in this slide is just a variety of different headers, and each one of these actually have more policy components to them as well. So this is just a sort of overall slide of a variety of different policy changes that were handled inside of the budget. But what I want to do is cover just a couple. So if you're still there, Doug, can you move to the next slide? Looks like he had to step out. I think he had to help Robert get on his transportation. But What I will cover though for you is we had a few things here I wanted to highlight. And one is for regional centers, emergency services. We talked a little bit about some bills that touched on emergency services. Emergency services is a very important area of policy change in California for various departments. So for regional centers in the budget, there are a variety of new things that must be in place related to emergency responses of each regional center. So we are developing a program of different things and that we'll put in place and different policies we'll put in place. And in addition to that, we'll be hiring an emergency response coordinator. And so for us, that emergency response coordinator will work into 3 different levels. One, they'll work with all of our providers. So if an emergency occurs, that will we'll narrow it down to where the emergency is, what type of emergency it is, and they'll connect with all the providers and make sure that we have a sense of what the plan is and what's happening for the safety of people with disabilities that we all support. And then there'll be a continuous check-in with that until we know where everybody is. And then we have another level where we're checking in with people who live on their own or people who live with their families. And then that person is going to be coordinating with all of them, all the people in charge at the regional center that can get to all of these families and know where people are, and that makes sure that everybody has been accounted for. So that will be a very big lift as well. And then the other level is our staff. So we want to know where all of our staff are. And then so we'll be working with our personnel, our HR department there. So this one person will be working with all of them as well as partnering with all of our local emergency response officials. So they will have this full system in place. And it's really going to be very helpful, and we're really excited to see this going in. We're very close at our regional center to hiring this person any day now. Another one of these is the deaf and hard of hearing services specialist. So what this person will do is a couple of things. One is work with existing providers to help them to make sure that they provide the services necessary so that people who are deaf or hard of hearing could access their services better or fully. And so they will work with existing providers in those ways. They will work with bringing on new providers who are either providing specific services to deaf and hard of hearing population, or bringing on new providers who aren't, and make sure that they have the capacity to provide their services in a way that also is responsive to the needs of people who are deaf or hard of hearing. So they'll have that component of their job where they're bringing on and working a lot with the providers. So they'll be housed in our community services section. And then they'll also have this other component where they're working with us in the regional center and helping us be more linguistically competent in working with the deaf and hard of hearing community, and also more culturally competent, and then a better understanding of the needs of those who are deaf and hard of hearing and the cultural components that we should know about. So there'll be that as well as, and then finally the outreach to the community. So that was done in the budget, and it's a policy change for all the regional centers. So we're really excited that we'll be able to do some new things in this area. We have another area in the budget that's a policy change. It's more of a policy enhancement, as it has to do with being more culturally competent and reaching out to our underserved communities and finding better, more enhanced ways of connecting with our community that are not using our services right now. And so for our area, we have a very large, fast-growing Hispanic population. And what we've noted is that in certain age areas that we serve, they're not receiving the services very much. And so what else can we do to connect better with these families and talk to them more? And so we've got new caseloads. They're going to be enhanced caseloads, so there will only be about 40 people on each caseload. And we'll have 5 of these service coordinators and they will be working with them and have a better opportunity to spend more time with them and explain maybe what the services are and how they could benefit them, and then also understand their needs, and maybe there's something different we could do that we haven't thought about yet. So again, another policy change. So we're doing a lot in the area of cultural diversity, of equity, but this sort of enhances the equity issue, and it was done, it's a policy change, but done in the budget. And then another enhancement is the participant choice specialist inside the self-determination model. So a lot of you are familiar with the self-determination. It's a policy inside the Lanterman Act, so it's a law, right? So that's an existing law, the self-determination. And then another change that occurred during the year is enhancements to participant choice budgets and services. So that occurred, and what we're doing here in this section is we're creating these positions. We have the laws calling for 3 new participant choice specialists, and they will help in participant choice services. So that means self-determination and participant choice services that are similar. So that's a bigger umbrella. And so that's another policy change that's done in the budget. And we're looking forward to being able to expand on the services that we have for those in self-determination, and then also in using the participant choice services. So watch for that as well. Provisional eligibility is also a new, brand new policy idea, and change in law changes the Lanterman Act, and it was done inside of the Budget Act. So this one allows the regional centers to expand their eligibility slightly. So once a person normally in early start reaches 2 years, 9 months, they would be reassessed to see if they were going to move from early start to regular Lanterman Act services, or that they were not eligible anymore, and we would refer them to something else that they might need. And the schools also do a lot more during that time as well. But what this does is that it says that it changes the eligibility temporarily for 2 years. So once they hit 3 to when they hit 5, that period of time, we're looking at reducing the threshold for eligibility, and we will be able to maintain some of these kids longer, and to see, did we not have enough information? Or we'll have more confidence on whether or not they will be eligible long-term for Lanterman Act services. So maybe they'll, at the end of that 5-year period, it's actually reassessment again at 4 years, 9 months. So at the end of that period, maybe they become eligible full-time, or maybe we have had the chance to intervene in a way, and then they wouldn't need lifelong services at the regional centers. And so that we can help the family in that way. So, and then another change that's kind of big for us is that in the family resource centers, they will now have the community navigators. And again, that kind of goes to the enhanced caseload sort of idea, and trying to make sure that people that are underserved are able to access all of the services in their community. And we're going to give them an enhanced opportunities here by working through our family resource centers, and they'll be able to give them this additional person who understands the systems. Usually will be a parent who has already been accessing the system, and that can help them more. And all the regional center areas will get one. And so we will have one here in our area. So that is another helpful thing and change in law. And that will change the Lanterman Act that was done in the budget. But the biggest thing, and maybe the most impactful thing that the state has been able to do is this time that there's a commitment for rate increases for the provider community. And this is a huge change in the Lanterman Act. It will begin in April, and it's over 5 years. And it will, each year there's a dedicated increase. And what it does is in many areas, most areas, it increases the rates to providers to get closer to what the state came up with, what their payment probably should have been for a while, done through a whole analysis that the state did. So anyway, this is a really exciting thing. Additional funds to the providers to help stabilize our provider community and build our capacity. And it will be done each year over the next 5 years. And then finally, performance incentives. I just wanted to mention that kind of quickly. And that is just that we're going to be re-looking at what are all the outcomes that we should be achieving in the regional center system. So what should regional centers really be doing? And when they do them, maybe we build in some financial incentives or some incentives in place for the regional centers to achieve them. So some outcome-based system for serving people with developmental disabilities. So that's just a quick summary of the many, many different changes. And we wanted to bring that up just to remind people that the laws change, and sometimes they change in ways and in places that are not the traditional place that you think of them, which would be the bills. So that would be mine. And I will move on to our illustrious chairwoman, Linda Mendoza.
Thank you so much, Tony. So first of all, I'd like to thank our presenters that we had today, Karen, Robert, Dina, Doug, co-chair Candace, and of course, Tony. And also with the information that we provided for the audience, I know it might have been a lot of information or maybe not enough information. So right now, Doug, if I can have you come up and tell them where they can get this information on our website.
Yeah, we will we'll definitely post it on our committee's page on our website. The legislative committee has their own page under the board of directors section on our website. So we'll post it there. We will share it on social media. So on our Facebook and Instagram and Twitter accounts. And maybe Tony, we could even include it in the health advisory that comes out Friday morning as a link as well. So there'll be a lot of opportunity for folks to in a lot of different places, even on our YouTube page, we can put it for different places for folks to access this, and they can always reach out to myself or Tony if they need to find where we house it.
Again, thank you so much for everybody who took the time to present, and for those that are watching this presentation. Anything, co-chair Candace, you'd like to say as we close out?
No, thank you for the opportunity, and go California.
Thank you so much. Tony, anything before we close out?
Oh, you never want to give me an
Oh
opportunity to say more.
Linda,
A few
what are you doing?
words.
I just say thank you to the committee. It's a lot of hard work, I know. And so I'm very appreciative of all the hard work that you guys put into that and trying to study these bills and understand them and understand the political process as well. It's not easy to do, and you guys all do a great job for our community. So thank you.
And thank you so much again. Have a nice day.
Bye.
Bye.